facts in this case. I've considered your prior record in this case. And I've made a couple of observations about this case ultimately. And I don't know if what I say, frankly, is wasting my breath, but it does strike this court that the Sunshine Law violation was probably one of the most egregious ways to violate the Sunshine Law. And I have to consider, frankly, the facts of the case and how serious the law violation is. And also your criminal history, which is not significant, but it's also not insignificant either. It exists, it's there. This is not the first time you have been in front of the court or a judge on criminal activity. Whatever happened in the hallway doesn't matter to me today. Okay, that's another issue on down the road. So I'm not considering that at all. I know, and I just bring that up because I know your attorney mentioned that in his argument. It really has no effect on what my sentence is today. At the time that this violation occurred, the people of Sebastian were in the middle of a pandemic, and none of us knew what was going on. And I've heard a lot of, and I respect the fact that you've stepped up to the plate and you've decided to become a public servant. I respect that fact, and I've heard that argument made to me. The problem that I have is that all flies in the face of what happened that day. What happened that day is you all took a meeting, and instead of doing anything to help the people of Sebastian, you removed people, and you knew what you're doing was wrong, because when the police showed up, you all ran out of the building instead of still continuing to conduct the business. And I can't ignore how significant that violation is of the Sunshine Law, but I do weigh it against the fact that, look, had you not stepped up to the plate and become a public servant, you wouldn't have opened yourself up to violating the Sunshine Law. So that there is some mitigation there. The other fact that I, along with everybody that I think puts on the road that walks into court, is whenever you raise your hand and you go under oath and you lie, that is also a serious violation of the law. The court system simply cannot function in an appropriate manner if people were allowed to lie under oath to get away with it. So I am going to punish you for both of those factors. I don't believe, essentially for someone that has never been to jail before on a criminal violation or a very insignificant time, giving you the maximum would be appropriate. I don't believe that. I've got to weigh the proportionality of, frankly, circumstances that you were involved in when this happened. So at this time, as to count one, which is a violation of the Sunshine Law, I will sentence you to 45 days in the county jail. I will also fine you $500 in order that you pay restitution in the amount of $26,098.50 to the city of Sebastian. As to the $15,000 settlement agreement, I'm not going to order that. I'm going to reserve jurisdiction on that amount because, frankly, the insurance company wasn't here to request it, and I don't think it'd be appropriate for me to ask to order you to pay that money at this time. As to count two, I'll go ahead again and sentence you to 45 days in the county jail, adjudicate you guilty on both counts, and fine you $500 as to run concurrent. As to count three, which is another violation of Sunshine Law, again, 45 days in the county jail, $500 fine, and an adjudication of guilt. As to count four, the perjury charge, I am going to sentence you to 6 months in the county jail, fine you $1,000, and also have that run concurrent for a total of 6 months in the county jail, will be the longest part of your sentence, and I'll give you 3 days for credit for time served. I'll also order that you pay court costs of prosecution and costs of investigation. I'm going to reserve ruling on costs of prosecution and costs of investigation at this time by agreement from everyone. Madam Clerk, the additional court costs.
For count one, the additional court On count 4, an additional $25. I'm sorry, count 4 would be an additional $50. And count 3, an additional $25.
Obviously, you have 30 days from today's date to appeal the judgment and sentence, and we'll address the notice of appeal and get these set on a supersedious bond at that point. I'll hear argument, and then we'll go from there. So just have a seat for right now.
Yes, sir.
At the end of this will be fingerprinted. Yes, sir.
Judge, I think that Mr. Gilliams originally posted a cash bond check, so we would ask the court to direct the clerk to apply a cash bond.
Yes.
To whatever is owed.
Okay. And I'll grab that request. Ms. Parris? Ms. Parris, likewise, I do agree with frankly all the arguments that I've heard today, and if it's easier for you to have a seat, that's fine.
Thank you, Judge.
I, for 1 second, don't have any idea what it's like to be in either of you all's shoes right now. And I understand that this is a very stressful moment. So, again, Ms. Parris, though, I can't ignore the fact of what occurred as far as the Sunshine Law violation happened that day. That's probably one of the most egregious ways you could violate Sunshine Law. And then on top of that, again, 2 perjuries, you commit perjury twice to law enforcement officer and the prosecutor, which again is a crime that touches the very fundamental nature of our justice system. So I can't ignore either of that. And also you do have a criminal history here. And I can't ignore that as well. But at the end of the day, I don't find you as culpable as Mr. Gilliams. And my sentence will be for you as follows. As to count 1, the violation of the Sunshine Law, I will adjudicate you guilty, fine you $500, and sentence you to 30 days in the county jail with credit for 2 days. As to count 5, as to the perjury count, I will sentence you to 90 days in the county jail, adjudicate you guilty, and fine you $1,000. As to count 6, 90 days in the county jail, adjudicate you guilty, and fine you $1,000 as well. Those sentences are to run concurrently. I'll reserve on cost of investigation and cost of prosecution. Madam Clerk, the additional court costs.
As to count 1, an additional $243. As to count 5, an additional $50. As to count 6, an additional $50.
At this time, I'm not ordering probation in either case, a straight jail sentence. Mr. Gilliams, I'm going to request to be fingerprinted at this time with Deputy Appelon, and then we'll address the stay and the appellate issue. And after that, Ms. Parris, she'll be fingerprinted by Deputy Appelon. Restitution,
No,
Mr. Parris, I'm also going to order that you pay $26,000, $26,098.50 in restitution. That will be joint and several with this case.
Your Honor, that was identical with Mr. Gilliams?
Yes. Mr. Garland, can you direct me to the statute for supersedeas bonds?
I'm thinking it's either 903.132 or 924.065. It's 924.065.
The orders I gave you said the total restitution, and I understand you're retaining jurisdiction to consider the insurance company.
Yeah.
Perhaps go through the word total, the total restitution to the city of Sebastian, I think is accurate in the report.
Yeah, I mean, my stance on that is if the insurance company wants the restitution, they can come and report the county up and face everyone and answer to that, and if they're entitled to restitution, I'll order it directly to them.
Thank you, Your Honor.
No. You can have a seat. Okay, so as to the notice of appeal, which I have both of you all, I know Mr. Garland's attached a notice to appeal. Are you filling that out, right, Mr.?
I am, Judge. I had to create more plain lines, but otherwise.
I don't have that, but I have my laptop and internet connection, I can do that in 5 minutes.
Okay. Is there any objection to going ahead and hearing the issue on the appellate bond and just letting Mr. Reisenstein file a notice of appeal?
No objection.
Okay.
No.
So that, do you think you can do that by close of business today? I know it's been
I
a full
will,
day already.
Well, I have a 3-hour drive back, but I
Close the business tomorrow, can you do that?
I can, but I can also do the courtroom decision, I have my laptop.
Okay.
If that makes you feel comfortable.
I'll just give you until the close of business tomorrow.
Well, that helps. Certainly.
Judge, can you ordered 45 days of county jail for Mr. Gilliams on count 1, 2, and 3, right?
Correct.
Of course,
You want me to be heard on motion?
No objection to him, Mr. Eisenstein doing it or making his argument now and following it up by pleading.
But
let's not waste time for that.
What's the state's position on Ms. Parris posting it?
We object to both. It was a clean trial. I think the standard is justiciable issues. I'd suggest that they won every argument they made and they got a fair trial. There were no issues.
Well, if I won every argument we made, we wouldn't be here. You would have issued a judgment of acquittal. Or you would have issued a motion for retrial. And I say that, and I appreciate the humor in it, but I'm also very serious. There are, and I don't know that I need to repeat this to you continually, but significant issues with both. But I'll start first with the rule of criminal procedure 3.691. Allows for a release on a supersedious bond, and it instructs the court to apply the principles of Youngins, Y-O-U-N-G-H-A-N-S versus State, 97-2nd, 308, Florida, 1956. The trial judge might consider one, the habits of the individual with respect to the law, local attachment to the community by way of family ties, business, or investments. You've heard that she lives in this community, works in this community, owns a home in this community. Severity of punishment and other circumstances relevant to the question of whether the person will be tempted to remove, it says himself, but obviously these days can say himself or herself. The court should also consider whether the denial of bail would render